Proceed.
Well, Your Honors, may I please support? My name is Marie Borland. I'm with the Woodward Henderson Law Firm. I'm here today with my co-counsel, Chris Altenberg, and together we represent the appellate Hillsborough County Aviation Authority. I'd like to reserve 5 minutes for rebuttal.
Yes, ma'am.
Today, we're requesting that the court reverse the trial court summary judgment order upholding the property appraiser's assessment of the aviation authority's exempt government property. It is indisputable that the operation of a public airport is a governmental function. The aviation authority has been tasked with that governmental function, and as such, its property is exempt from ad valorem taxation. It's also indisputable that the uses of the property at issue in this case, all of them, fall within the aviation and airport and FBO exemptions that the legislature set out in section 196.126.
Let me ask you a question about the uses as the folios describe them. It's hard, given the descriptions in this record, to discern, that in various folios, for example, Tampa Executive, we've got 94% exempt and 6.3% taxable. We've got a law office and a shipping logistics company and aircraft warranty sales, a fuel farm and flight school. And so how do we know that the 6.3% taxable isn't attributable to the law office? And if it is attributable to the law office, how does that fall within the statutory text that says, you're exempt if you're in an aviation area and the property is used for administration operation? That incredibly clear statutory text that ultimately concludes with FBO.
Okay, well, Your Honor, and I understand the court's concern. So within the language of the statute, all FBO property is exempt. The legislature has stated that.
So is a law office an FBO
Well, so,
property?
Your Honor, to the extent the record might be unclear about that, that is up to the property appraiser to clarify. This is a summary judgment order. All FBOs have to be exempted 100%. Now, we know that this 6% that he claims that is the only part that's been taxed, that incorporates the entire FBO leasehold. We also know that there is no law office at that airport.
Well, how do we know that?
Well, Your Honor, to the extent that's important to the court, we don't think it's dispositive because.
And I'm really using this as an example for what I think is, to some extent, a pervasive issue with this record.
Right. Well, again, Your Honor, it is up to the property appraiser on summary judgment. For the property appraiser to get a summary judgment, there have to be no issues of fact.
And both sides agree. Each of you filed motions saying there's no disputed issue of fact.
Well, Your Honor, because we know that these FBO leaseholds are exempt in their entirety under the plain language of the statute. We understand and we know that all the uses by these FBOs fall within the definition of what an FBO does. We happen to know that there is no law office at that FBO, but to the extent the record is unclear, then that's up to the property appraiser. But we don't think that precludes the court from entering summary judgment because the property appraiser has assessed 100% of every FBO leasehold. He claims he hasn't, but he has. The FBOs lease a small portion, physical land of that property, and those portions have been assessed 100% in their entirety.
Let me ask you another question going to the uses. The cargo services for, I think it's UPS and then LGS Logistics, are those aviation or airport related functions as defined in 196.0126? And if your answer is yes, and I assume it is, I'd like to know what your authority is.
Okay, so again,
because these are for-profit companies moving cargo around.
So the best authority really for that, and of course not binding on this court, was Judge Levin's very analytical decision in the summary judgment order in FedEx. And he talked about FedEx, which is a for-profit cargo transport company. He said simply by being for-profit certainly doesn't preclude someone from performing a government.
So in a perfect world, you would like Judge Levin's order to be an opinion of the Second District Court of Appeal that we should follow. I was prepared
to submit today that Judge Levin's summary judgment order provides a perfect blueprint for this court to reverse on the basis of 196.0126. He said a cargo transport is in the common usage of the terms aviation and airport. It fits squarely within the statute and on that basis.
And well, there's one thing in Judge Levin's order that jumped out at me, which was that FedEx was deemed a signatory carrier. And I'm not sure where, and maybe you can help me, in this record, UPS and logistics would fall within that definition or the parameters of what Judge, because that was a big part of Judge Levin's reasoning. So can you help me out with that?
Well, I didn't really find that in the legal analysis, that was really the basis for his legal ruling. He talked about it in the factual background, but to the extent that it was, it really doesn't matter because the legislature has said aviation and airport uses by definition are exempt functions. And why? The Aviation Authority has been charged with operating all public airports in Hillsborough County, not managing, operating. And they, on the record, and it's undisputed, the Aviation Authority has said, if we don't have these cargo transporters, we don't have all of these different lessees, the FBOs, we're going to have to do it ourselves at great cost to the taxpayer. So to answer your Honor's question, whether FedEx, with regard to whether FedEx was a quote unquote signatory airline, it really is indistinguishable. FedEx is indistinguishable from all of the other uses in the eyes of the legislature. And taxation is a creature of statute, and the legislature in its wisdom has said, and it makes sense, that any aviation or airport use, traditional aviation or airport use that has to happen within the confines of the airport property, those are by definition governmental uses. So I hope I've answered your Honor's question with regard to Judge Levin's ruling, but I think that it's squarely on all fours with this case and does provide a perfect blueprint for a reversal on the statute. He cited some other cases, the FBO cases.
What about the Supreme Court's articulation of this governmental purpose case from I think it's the city of Jacksonville opinion? What do we do with that?
Okay, so it was really first articulated in the Williams versus Jones case in the 1970s. That was when this statute I think it had one sentence. The legislature had not added all of these specific governmental uses at that time. And that was a case where barber shops and retail shops and beauty shops, et cetera, on Santa Rosa Island were receiving exemptions because they were operating on government property. And they said, well, we're operating on government property, we get exemptions. And the Florida Supreme Court came in and said, no, you don't get a market advantage because you're operating on government land. Everything you were doing could be done off the property. You could do it on Miami Beach, et cetera. And that was the test for governmental use. If it can be done outside of governmental property, it's proprietary in nature. The court found that those uses were proprietary in nature because of that. In this case, in clear contrast, it's undisputed that everything that's happening at the airport with the uses of these properties has to be conducted on airport property. You can't repair aircraft on like 275 or Dale Mabry. You can't do any of these functions outside of the airport. So by definition, and under the Williams versus Jones articulation of the government test, the lessees fall squarely within that test. The legislature recognized that and recognized how important it is to have airport operators, to have the Aviation Authority have the ability to outsource to airport operators. That's why the statute was amended in 93, and again, I think it was 97, first to add the FBO exemption, then to add the more general aviation and airport exemption. And I would mention to this court that in the nearly 30 years, that statute has been on the books. No court, no appellate court in this state has challenged or said that those uses, any of these uses, don't fall within those exemptions. This would be the first court.
Let me ask you to shift gears. Going to your second issue on the denial notices. Assuming that we would agree that the denial notices were insufficient, non-compliant with the statutory requirements for a denial notice, the statute says the notices are invalid. What does this mean? And if we focus strictly and exclusively on that point, what effect would an invalid notice as a basis for reversal have on the proceedings?
So the Genesis Ministries case, it says that they're void. So basically, the denial of the ad valorem, the exemption is void. It doesn't exist. So the BAD's determination,
and that would be self-executing.
Yes, they would not be entitled. Yes, the property appraiser could not rely on those exemptions. But on that point as well, under 196, 1995, the more important point we think is that the property appraiser we would submit really didn't even have the authority to send out the denial notices anyway, because he had no authority to usurp the role of the VAB to step in and deny the exemptions. That's the second basis for reversal, is 196-1995, that very clearly says, it mentions the property appraiser by name, very clearly says your role is limiting to making findings of fact, submitting those findings to the VAB, and the VAB is the body that makes the determination of whether the leasehold uses are exempt. And for good reason, because the VAB is a neutral body, whereas the property appraiser has an incentive, as has happened in this case, to declare those uses taxable. So in its wisdom, the legislature said, property appraiser, you don't have any role other than you just tell the VAB what your findings of fact are. That's not what happened here. The property appraiser usurped the role of the VAB, decided to issue these
And this leads to your next issue. Since I don't want to use up all your time, but on your opponent with regard to the subject matter jurisdiction question contends essentially that the allegations of the complaint set forth a statutory violation by the property appraiser, taking this case out of the scope of the Supreme Court case where the property appraiser challenged the constitutionality of the statute itself. And so my question to you on the subject matter jurisdiction issue is, given the allegations of the complaint that the VAB improperly reinstated the exemptions, hasn't the property appraiser invoked the subject matter jurisdiction within the meaning of the statute for purposes of this challenge, 194.036?
So, Your Honor, no, we would respectfully disagree. And the case that we're relying on is actually this court's decision in Turner versus Hillsborough County Aviation Authority, where this issue was, in this case,
but that way he would, in that case, the property appraiser was, as I read the case, was challenging the constitutionality of the statute as it was, as opposed to alleging a violation by the VAB of the statute.
So, Your Honor, in fact, that's not what happened. And if you, and I've read the Turner opinion many times.
Probably many more than I have.
Many times. And there was not an allegation. The property appraiser will say that there was, but if you read the Turner decision, what he claimed was that the VAB violated the Constitution in the way that it applied the statute. So he never made a constitutional challenge to the statute itself. Yet this court said in Turner, and it was the exact same statute, 196.0126, a different subsection, but said because that involved a stadium and because it fell squarely within the criteria of the statute, just like the uses do here under the aviation and FBO exemptions, simply by virtue of the fact that the property appraiser was refusing to apply the exemption meant that he was challenging the validity of the statute, which of course.
And that's really the gut of my question to you, because the allegation here for me that I need to understand why it's within or without the Turner reasoning is here. The allegation was that the VAB improperly reinstated the exemptions. And I don't know if you've told me everything about why that's the same as Turner, or if you're acknowledging that there could be any differences given.
So with regard to the complaint, what we're saying is the statute is very clear that the property appraiser's standing to quote unquote appeal a VAB decision is limited to property appraiser's ability to specifically assert a specific, or to affirmatively assert is the language, a specific constitutional or statutory violation on the part of the VAB.
Well, if it's not enough to say improperly reinstated the exemptions, when can the property appraiser do that?
I'm sorry, when can the property?
If what was alleged here is not sufficient to satisfy the statutory requirement to invoke the jurisdiction of the circuit court, what would be?
So, for example, if he would have said a specific, I'm shooting from the hip, a statutory violation could be that the VAB didn't handle the proceeding in the way that it was supposed to under the statute.
So due process type.
Yes, sort of. The VAB didn't follow the procedural requirements of the statute with regard to the conduct of the hearing, or it went sort of rogue and did something it had no authority to do. But by saying that we disagree, basically what he's saying is we disagree with the VAB's application of the statute.
Fair enough. And one last question for you, just moving through your issues. The trial court concluded with respect to issue 4 that subsection 1995, 196, 1995 doesn't apply because the statute only addresses leasehold and the aviation authority holds a fee interest. This seems to me to be a non-issue. Tell me why I'm wrong.
I'm not understanding Your Honor saying it's a non-issue. Do you mean that you agree with, say, for example, Judge Levins when he said that the statute does apply under these circumstances?
No, I'm questioning your attack on the trial judge's conclusion here that the statute doesn't apply because the statute governs leasehold interests and the aviation authority holds a fee interest. That's the way I understand your argument.
Okay, well,
Perhaps I
it's quite an
misunderstood.
important issue, Your Honor, and clearly the statute does apply in this case. If you look at the context of the statute, it's in Chapter 196. It is part of the determination of whether the government's real property is exempt from ad valorem taxation. And the way to do that is to examine what the leasehold, how the lessees are using it, which is what subsection 5 talks about. If there weren't any leaseholds, then that wouldn't be there. But the determination to be made is the real property or the dirt, as Judge Northcutt called it in the related Gulf Marine appeal. He acknowledged that this statute applies to the dirt, not to the intangible tax. The property appraiser wants to get out from underneath this statute by claiming that, oh, well, it just applies to the intangible tax. It doesn't say anything about intangible. It talks about the property appraiser, and honestly, it's written into the statute as well, subsection 2 of the statute that says when a determination has been made that the lessee is using the property for governmental purpose, that shall apply to all interests in the property, which would be the real property. So 196, 1995 indisputably applies in this case. The trial court was 100% incorrect in its analysis, and the trial court, with all due respect, was misled by the property appraiser's arguments. I'd like to say one more thing about that statute to just seal this. The property appraiser will say, oh no, that just applies to leasehold interests and we assess real property. Well, that's what we're here for today. We're talking about the assessment of real property. So that is a bit of a red herring. And secondly, he has conceded on this record that he is bound by that statute because he has conceded that Judge Levin's summary judgment order in FedEx is binding on him. It can only be binding on him if he is invoking the sentence of 196, 1995 that says if an exemption is granted by judicial proceeding, it shall apply throughout the duration of the lease. So even the property appraiser should be stopped from arguing that that statute doesn't apply.
You're at your rebuttal time as well.
So I hope I've answered your Honor's question.
Thank you.
Unless the court has any further questions, I think we've already pretty much covered the arguments. We believe that there's a basis for three independent bases for reversal under 3 separate statutes, and that there are templates in place through Turner and through the FedEx order that would provide some, well, a template, not that the court needs it, but for independent reversing.
It's fine. We'll have about 4 minutes to go and we'll get back up. Counsel.
Please the court, Bill Shepherd, General Counsel for the Pittsburgh County Property Appraiser's Office. The Aviation Authority argues this morning that this court should reverse the trial court decision. But what they're really asking this court to do is to reverse 50 years of case law, including numerous Florida Supreme Court cases that say that the governmental test is how we look at.
Well, wait a minute. I mean, the legislature has given us and given you and the Aviation Authority a pretty concrete and detailed roadmap that applies specifically in this context. And that the operative part for purposes of today, having to do with FBOs, was enacted after a lot of the case law that you're talking about. So let's focus on the statutory text and what it says about exemptions for property, real leases of real property on aviation areas where the property is used for these purposes, and specifically the fixed base operations, because I'm going to be very straight with you. Looking at these folios, these look to me like fixed base operators. And that doesn't sit right to me with the statutory text. So help me out.
So the statute sounds pretty clear until you look at the facts of the case. It's easy to say FBO or airport or aviation. What does that really mean in this context? At this airport, we have a hotel. we have restaurants.
But we're not talking about hotel and restaurants. We're talking about cargo and aircraft repair and fuel farms.
That's correct. But does that really fall under a governmental aviation or airport use? And when you look at the FBOs, all the subtenants they have, suddenly those terms don't become very clear. And the courts have given the property appraisers guidance in this area. They've said, when you look at this statute, here's what you do. Here's what you look at this governmental versus governmental proprietary application. So let's take a look at the uses.
Well, but I understand your argument. I've read the cases, but I've also to some extent interested in your response to what your opponents amicus have said about this, which is assuming this exemption remains withheld, for lack of a better way, assuming this taxation is permitted, it creates a situation where the airport is going to be charging rent that these fixed-based operators aren't going to be able to pay, given the market for the services. And then the county, or I'm sorry, the airport authority, is then in the position of needing to supply these services to keep airlines running and the airports running. And that can't be that's a bridge too far on this governmental purpose and the precedent that you're relying on. At least that's what your amicus say. So can you address that?
Well, if you're looking for a public policy argument, I guess you could.
I'm not looking for a public policy argument. I'm just asking you to address the pragmatics of once these taxes are levied, the pragmatic fallout. And they solicited amicus, they filed briefs, and this is what they're talking about. I think it's a legitimate inquiry, and I'd like you to address it.
I suppose the pragmatic fallout is that the aviation authority will have to charge a rent with a pass-through provision for the taxes that makes sense in the marketplace, which is what any other landlord does. They look at if the taxes are this, they look what the rent will bear, what will these tenants pay to stay here. And let me make this point. When this litigation, I've been general counsel for the property appraiser for a long time, since litigation in the 1990s, with both the aviation authority and the port authority, they screamed bloody murder that we were going to destroy the port and destroy the airport by taxing the restaurants and the hotel at the airport. And
Is that in the record?
that is not in the record. But the point is that these entities succeed when there are various taxed subtenants at the airport. It has not destroyed the airport.
Well, so it sort of points up a question that probably has a similar amount of record deficiency, but isn't it the case that these folios were exempt until 2019?
So this relates to the related cases. This came out of the Gulf Marine case, was one single tenant at the Port Authority, and they filed an equal protection case and listed about 115 properties that they claimed, look, you're not taxing these guys, why are you taxing us? In that case, we worked through those, found out that every one of those either were taxed, there was appropriate reason for them not being taxed or exempt, wasn't actual, with the exception of these 15 or 16 properties. Of those, we said, well, there's 15 or 16 here that we were not aware of what activities were taking place. It's hard to get onto the airport property as it is the Port Authority property and access this.
Well, you didn't think they were running a Dave & Buster's out there.
I'm sorry?
You didn't think they were running a Dave & Buster's entertainment restaurant.
No, we didn't think there was a law office and other activities out there. So suffice to say that we didn't catch these before. I wouldn't say that they actively received an exemption. We just never put them on the tax roll. So let's just get right to the point of 196.012 sub 6. We have plenty of case law prior to that says these exact uses are taxable. We have the Bailey versus Fernandina case. We have the old Walden versus HC versus Aviation Authority case. Numerous other cases that suggest these uses are taxable under the statute. But then we have the amendment to the statute that says FBOs and says aviation and airport uses. But here's what the Supreme Court has said about these amendments to statutes where there's already been a court judicial determination. The court said this: the legislature is presumed to have adopted prior judicial constructions of a law unless a contrary intention is expressed in the new version. In other words, the Supreme Court's view of this is, if there is an amendment to the statute, like there was here, unless it specifically identifies this is meant to overturn these court cases, that the legislature is
Okay, that you're
understood
asking us now to
embrace.
look at legislative history. And so I'm going to ask you to move to something else.
Right.
Several of the folios at issue are, it looks like they are 100% cargo related. And I'm going to ask you the same question I asked your opponent. Why aren't the cargo services considered aviation or airport related functions as defined in 1960126?
Okay, so we have UPS, we have Amazon, we have et cetera. Let's put it in this context. UPS and Amazon could easily lease space from the city of Tampa downtown.
Could they land their planes downtown?
No, but they have other operations. So would we exempt UPS because they lease
Well,
land
then
from
that
the city
you
of
walked
Tampa?
right to the precipice of your opponent's, one of your opponent's more persuasive points, which is, what about Judge Levin? What about Judge Levin's order? Why doesn't it apply directly here?
I think Judge Levins was incorrect. At that point, my client decided not to appeal that decision.
Why was he incorrect?
Because I think he was wrong about that. Federal Express is quite certainly a private company interested in private profits and has nothing to do with the sovereign function of a government.
So your position on that order is you're bound by it for purposes of FedEx. We raised judicata, as I understand the briefing, but it was wrong and you all just elected not to appeal at that time.
We elected not to appeal it at that time, and we elected not to tackle that issue until now.
So let's go to the second issue. I'm obviously tracking your opponent's arguments. The notices, the denial notices, the statute is pretty specific about what's supposed to be in them and the detail that's required. Your opponent argues that the notices that were given are sort of boilerplate and insufficient. And I've looked at the notices and they are boilerplate. They say property does not meet statutory criteria and then spits out a bunch of statute sites, whereas the statute requires specific factual findings. Where are the specific facts that the statute requires in these denial notices?
When you look at a governmental use application, there are two issues. Is it owned by the government? Is it used for?
Well, tell me where in the notices the specific facts are. Let's do that. Because what I see are cites to case law and property being used for non-exempt proprietary purposes. That's probably the most specific. But these are not facts that are specific to these folios, which is what the statute seems to require for the denial notice.
So what the statute requires is that a reasonable person can look at the denial notice and understand what's there. When the property appraiser says the uses are not governmental in purpose, who knows better what the uses are?
Well, what it says is a reasonable person can understand specific attributes of the applicant's use, which form the basis for the denial. And that's what I'm struggling with here.
So I find it hard to figure out what more the property appraiser could say than the uses are not governmental in nature. I mean, I suppose we could laundry list the specific uses, but the aviation authority well knows what those uses are. And it's interesting that in this case, there was lots of correspondence going back and forth after those denial notices and a very detailed value adjustment board hearing, in which case the aviation authority made a full and complete argument based on the uses of the property. There's no question that the aviation authority and their attorneys
what the aviation authority knew and what the statute required your notice to contain could be two different things. And my question to you, and I think I've got your answer, is you think what these notices contain is enough?
I do.
Okay.
I think that when you say use.
So talk to me about your subject matter jurisdiction argument.
Okay. So the statute talks about a specific constitutional or statutory violation. Obviously, the property appraiser cites the statutes that we think the value adjustment board violated in their decision. Paragraphs 13 to 16 of the complaint describe the VAB's actions. Paragraph 19 says it's not entitled to an exemption under those statutes and
Well,
cites
and what your
case law.
opponent says is that this is the functional equivalent of the Turner decision, and your opponent's contentions have enough merit that I would like you to address them, please.
So, and that was again my case. And I don't recall specifically what the complaint said in Turner versus Hillsborough County Aviation Authority, but how the appellate court looked at it was you're challenging the constitutionality of the statute and slapped us down on that. And I don't disagree that in that case we argued because the Sebring case was working its way through the courts, through this court and the Supreme Court at the time. We said, hey, this statute can't possibly be constitutional. However it was framed in the complaint, I honestly don't know. But that's clearly not what we're doing here.
Is it,
We've granted tremendous amounts of this property that are used by the FBOs. So we embrace the statute. We just read it under the constitutional requirements that the Supreme Court has told us to do. They've said, if you read this statute constitutionally, you must look at it as governmental uses, some element of sovereignty, the administration of some physical.
I want to make sure I understand your position reduced to its simplest terms, and tell me if I'm wrong, okay? The way viewing most favorably to you, it is that the allegations in your complaint take you out of the Turner holding because you alleged that the exemptions were improperly reinstated, and put some color on that in terms of why. And am I understanding the essence of your argument? Because if I've missed something, now's your time to tell me.
Yes, no, that statute, which by the way, I don't agree has anything to do with subject matter jurisdiction. The courts have said subject matter jurisdiction is the power to adjudicate the class of cases to which the particular case belongs. Sufficiency of pleadings doesn't grant subject matter jurisdiction or not. If they thought it was unclear, maybe a motion for clarification.
Well, we can agree that at minimum, it's something like procedural jurisdiction, because the statute prescribes under what circumstances your client can invoke the jurisdiction of the circuit court.
So I apologize now, I don't call your original question.
Well, the statute says that the property appraiser may appeal the bad decision to the circuit court if one or more of the following criteria are met. And the one that you're traveling on here is a statutory violation, not a constitutional violation. That's how you're staying out of Turner. And I'm just trying to make sure I understand the totality of your argument. It is that the allegation, putting aside whether you agree or disagree that it's a jurisdictional issue, the allegations that you've made that flow from improperly reinstated the exemptions is how you hook on to the statute for purposes of arriving in circuit court.
That's correct.
Okay, I just wanted to make sure I understood.
Really, to go back to the uses, I know that unless there's so much you wanted to go over the allegations, but when you look at the uses here, fuel sales and their argument, oh, well, you can't fuel a plane on Dale Mabry. Once again, you can't fuel a car unless it's at a Citgo or a Shell next to a roadway, and Citgo or Shell could lease property from the city of Tampa. Would we then suddenly argue that Citgo or Shell is exempt just because it's on government property? They're selling fuel. It's no different.
Well, I think you're asking us to ignore what air cargo looks like when you suggest that these operations could be conducted off-site. And I think your argument pertains only to cargo as opposed to several of the folios, which are clearly repair and fuel farm and other things that can only happen on the airport.
Yeah, so keep in mind that we're not creating new law here. Page versus City of Fernandina Beach case, the Walden versus HCAA Aviation Authority case, all have cited these specific uses as being taxable. All the property appraiser did was apply the Sebring test, Williams versus Jones test, all the way back to 1995 and say, which of these uses are governmental, and and which of these uses are governmental proprietary. And you can't really say that the aviation authority would be out there doing cargo. You know, I think one way to look at these uses and this test is to say, where are areas that the general public can't step in? Obviously, cargo and fuel and corporate aircraft, these are all things that we think of private sector getting involved in because you can make money on them. The FBOs are not hired to do these things. The FBOs are out there making money. The FBOs do manage the airport, right? And that portion has been exempted by the property risk. There's a governmental function for exempting. We exempted the portion where they're operating the airport, doing all those governmental functions. But governmental functions are something that the private sector really can't step in. The private sector can't step in and be a court. The private sector can't step in and be the property appraiser's office or the clerk of the court. Those are things that taxes do because proprietary activities, that there's no way for them to do this unless the government funds them to do it. But these uses here are uses that are typically and traditionally private uses. Yes, they benefit the airport. That's what they're about, just like there are uses.
Well, they also fall within the statutory text that says they'll be exempt.
Only if you ignore the governmental test, which our office doesn't feel like we have the power to do. The Supreme Court's told us numerous times, here's how you have to look at this in order to be constitutional. Our office has learned the lesson that you don't, that you play under the Constitution. You don't challenge the Constitution. So I have to look at that and go, okay, I want to make sure I'm reading this statute in a constitutional manner as the courts have given me guidance in the past. That's ultimately what our office does. And again, the case law out there has already said that these specific uses are taxed. I think we've covered the intangible tax, the leasehold interest thing. Obviously, since 1980, it's taxed as a contractual right. So the statute about res judicata and the statute about VAB taking a role here in the denial laws is not accurate. I don't think this is a subject matter jurisdiction scenario. As far as the res judicata thing, we have this Crapo case. Each tax year stands on its own until that case really came out and clarified that. I think the property appraiser wasn't quite sure what to do with Federal Express out there. Are we bound by that? Are we not bound by that? Can we tackle that? Crapo case came out. Each tax year stands on its own, even for exemptions. Under that, I think. Does the court has any other questions? Thank you.
Thank you, sir.
Before you start, I'm just going to cut you off. I apologize for interrupting your flow. There's a question I meant to ask you on the main, and it is the trial. There in this order, the trial court found that to the extent some of these tenants, and I'm sort of quoting from the order, to the extent some of these tenants, FBOs, undertake management of regional airports, the property appraiser has exempted those portions of the property. And my question is, why should this court, given that finding, assume that the FBOs haven't already been properly exempted? And as a corollary to that, given that it was on the face of this judgment, is there a reason you didn't seek to clarify it? Or that's just a question that I have. And so if you could address that.
So Your Honor, the order was prepared by the property appraiser, and this court's review is de novo. And I've said this at the beginning, to the extent the court believes there's any sort of factual issue as to which VBO uses were taxed and which weren't, we don't think there are. This is something, I hate to say it, but it is made up that, oh, well, the management functions have been exempted. 100% of the FBOs have been assessed. They rent or they lease a very small, by the way, they do pay rent. The Property Appraisers Council suggests that they don't, but they do pay rent. So it's hard to quarrel with what the court said. We don't agree with it. There is no such thing as a management function. The FBO is operating the airport. These are operations. There's no way to carve out.
Let me ask you the follow-on question. I'm sure you're familiar with the principle that most easily announced in Pensacola Beach, Pier, and King. This error appears on the face of this judgment. You didn't move for rehearing on it. Have you waived it?
No, Your Honor, we don't believe we've waived it. We've briefed this. We don't believe this is a factual finding. There's no evidence in the record to support it for it to be.
But that's not my question. I mean, you know what the waiver issue that I'm asking about is, which is
Honestly, I'm not entirely.
where there's case law, and again, Pensacola Beach starts with it, where if the error appears for the first time on the face of the judgment, you are obligated to bring it to the trial court's attention. Funded Preservation 101.
Well, so Your Honor, this was argued during the summary judgment. We disputed it. So as is the case, I don't believe you have to seek clarification of something that you've already preserved. We argued to the court that this was incorrect. We argued there was no such
Okay,
thing
I'll
as-
take that answer. You've answered my question, and I'm sorry I used so much of your time.
That's
Please
okay. I
get.
just, obviously would like to make sure I answer those questions. And again, I think the court already understands this, but there is no separate governmental test apart from the statute. They are one and the same. The statute is the governmental test. By suggesting, by the property appraiser, really what he has proven he's doing is challenging the constitutionality of the statute, the wording of the statute. He's seeking to interpret it according to his the way he'd like to have it interpreted. That is a challenge to the validity of the statute. So no matter how you slice it, that's what's happening here. He doesn't like the language of the statute. Your Honor has noted, has acknowledged that all of the uses fall within the plain language of aviation and airport. There's no separate governmental test that comes swooping in and disrupts that. No court in over nearly 30 years has ever said that these exemptions in that statute are somehow invalid or mean anything other than what they do. He relies heavily on the Page versus Walden versus HCAA cases. Those were obviously they were prior to the statutory amendment. And what he doesn't understand is in Page, which was a case that he highlighted throughout his brief as supporting his argument, that was before the FBO amendment. And there's a footnote, and I think it's footnote 7, where the court says property appraisers stopped assessing airport properties after that amendment. So Page actually supports our position because it shows that once the legislature stepped in and clarified that aviation and airport uses and FBO uses are governmental in nature, the property appraiser in Page stopped assessing them, as the property appraiser in Hillsborough County should be following suit. There is no legitimate basis to be assessing these purely aviation uses.
You have about a minute to go on this point.
Okay, you talked about the Turner case. I don't know if the court has any more questions, but the Turner case says at page 176, the complaint alleged the decision of the DAB violated Article 3, Section 3A, Article 7 after Section 3 of the Florida Constitution. The property appraiser in that case, Mr. Shepard says that was his case. He doesn't remember what he alleged, but he did not allege a constitutional violation. Yet this court said, and I think the holding is important, Turner was without authority to change the legislature's definition of governmental purpose, which is precisely what he's trying to do in this case. Therefore, his refusal to apply the statutory exemption, which is the exemption in this case, the same statute rather, and his subsequent filing of a complaint alleging that the DAB violated the Constitution by granting the exemption, which is pretty much what he's doing here, are both acts that challenge the constitutionality of the statute. Turner is indistinguishable from this case. The property appraiser does not have the authority to come in and challenge the constitutionality or validity of the statute. That's what he's doing in this case, and in refusing to apply Section 196.0126 as written, 196.1995, and 194.03.
Good timing. You're all finished.
I appreciate it.
Next case is